Good day, everyone. So today we will learn a very basic concept in partnership law, and we are going to look at the definition of partnership. According to Section 3, Subsection 1 of the Partnership Act 1961, a partnership is a relationship between persons who carry on a business together with the intention of making profit. So let's break this into three simple points. Number one, relationship between persons. This means at least two people are involved. Number two, carrying on a business together means they must run a business as a team, not individually. And number three, with a view of profit. The main aim is to earn profit, not just for fun or charity. So a simple example, look at the picture between Ali and Siti. Ali and Siti open a coffee shop together and they both help run the business. Ali served the customer and Siti is managing the orders. So at the end of the month, they share the profit. So this is a partnership because they are two persons, they are running a business together, and they want to make profit. So a partnership is not just working together, but working together to run a business and earn profit. Next, we will learn about the types of partners in the partnerships. So there are four main types. Number one is active partner. So an active partner is someone who runs the business daily. They are involved in decision making and operations. Number two, dormant partner. A dormant partner only contributes money or the capital, so they do not take part in managing the business. Number three is nominal, a quasi-partner. A nominal partner only allows their name to be used in the business. They do not invest money and do not manage the business. And number four is the minor partner. A minor partner is a person below 18 years old. They can join with conditions, but they can only share profit, not losses. Next, let's continue with the characteristics. There are five important characteristics you must remember. Number one, there must be more than one person. A partnership must have at least two people. One person alone cannot form a partnership. Number two, relationship between partners. There must be legal relationship between the partners. This means they agree to work together. Number three, there must be a business. The partners must be involved in a business activity. For example, selling food, services, or products. Number four, business carried in a common. The business must run together, not separately. All partners work as a team. Number five, the main goal is to make profit. If there is no intention to earn profit, it is not a partnership. So, simple example for you, Ali and Siti open a coffee shop together, and here there are two people, they agree to work together, they run the coffee business, they both help manage the shop, they want to earn profit and share it, and therefore this is a partnership. So to form a partnership, all five elements must exist: people, relationship, business, teamwork, and profit. So let's look at the elements of partnership. We will focus on one important element of partnership, which is relations which subsist between persons. This simply means a partnership exists because of an agreement between people. The agreement can be written or verbal, and it shows that the parties agree to business together. Very important notes for you here is that a partnership is not a separate legal entity. This means the business is not separate from the partners. A case example for you, Wong Peng Yuan versus Sananya K. So let's look at a simple version of this case. G was a partner in the firm, and then G transferred his share to his infant children, and later a new partner, which is the plaintiff, joined the business. So when the business failed, the plaintiff said, I am not a partner because the children did not agree. So the court decision here, the court said the transfer to the children was only a transfer of profit, not making them real partners. Therefore, their consent is not needed. The plaintiff is still a partner and cannot avoid the liability. So in conclusion for you, partnership comes from an agreement between persons. It does not need to be written. It does not create a separate legal entity, and the partners are personally responsible. Next, let's look at case Keith Spicer Limited versus Mansell. This is an important case to understand when a partnership exists. So let's look at the facts of the case. Mansell and Bishop planned to open a restaurant. The restaurant had not started operating yet. However, Bishop ordered goods from a supplier, but Bishop did not pay. So the supplier then sued Mansell, saying, there is a partnership, so Mansell must also pay. So what is the issue here? Is Mansell responsible as a partner, even though the business has not started? So the court decision, the court said there is no partnership exists because the business has not started yet. So Mansell is not liable. So simple explanation for you, to form a partnership, there must be an active business. Just planning or preparing is not enough. So a partnership only exists when there is a real business activity and not just planning or preparation. Next, we will focus on an important element, which is the business carried on in common. So what does this mean? There are two key ideas. Number one, there must be a business. The business must already exist and operate. It can be trade, occupation, or profession. The purpose must be to make profit, not for charity. Number two, in common or together. All partners must have shared intention. They must manage and run the business together. They work with the same goal and purpose. So let's look at a case, Choi Siu Chong versus Lucky Height Development. The court found that there was no partnership because there was no common intention between the parties. Even if people are involved, but without shared intention, there is no partnership. So to prove this element, there must be a real business and the partners must act together with the same goal. Next, let's look at another important element of partnership, with the view of profit. So what does this mean? From the very beginning, the partners must have the intention to make profit. The business must aim to earn money or income. It is a profitable venture, not for charity. So important point for you to remember is that it does not matter whether the business actually makes profit or not. What matters is the intention to make profit. So it is not a partnership if the purpose is for charity, voluntarily, or non-profit activities. Remember, this is not a partnership. So to form a partnership, there must be an intention to make profit from the start. Actual profit is not necessary. Let's look at case Gulazam versus Norzaman and Sobath, 1957. The fact of the case, the parties agreed to form a partnership to buy bread and sell cattle. I'm sorry, to buy, breed, and to sell cattle. The defendant, which took care of the cattle, sold the cattle, and later the plaintiff asked for accounts, which is the profits and the records. But the defendant said there are no accounts to give. So the plaintiff took legal action. So what is the issue here? Is there a valid partnership and business even if proper records are not kept? So the court decision, there was a partnership, there was a business because actual transaction took place. Therefore, the plaintiff has the right to claim accounts and money. So partnership is proven by actual business activities. Even without proper records, partners are still responsible to each other. Now let's continue with the business carried on in common. So the business must be carried out by all partners or on behalf of all partners. This means everyone is connected to the business. Everyone shares the same purpose to run the business together. Some important note for you, sometimes the term syndicate is used. A syndicate can also mean a partnership if the parties work together and share profit. In the case of Ratna Amal and Anor versus Tan Chao Su in 1964, the fact of the case are the parties formed a group called a syndicate. Their business was to sell condensed milk. The same people were involved in the business and profit. So the court decision, the court said, if this is a valid partnership, the business is legal, the partners must share profit equally. So even if they use different name like syndicate, as long as they work together, run a business, share profit, it is still a partnership. So business must be carried by or on behalf of all partners. Name does not matter, partnership or syndicate. What matters is working together and sharing profit. Now, let's look at the rules to determine whether a partnership exists. Under Section 4, some situations do not automatically mean a partnership exists. This is called not prima facie partnership. So let's look at a joint ownership under Section 4A. Sometimes people own property together and earn profit from it, but this does not necessarily mean they are partners. So sharing property is not the same as sharing a business. The case, Davis versus Davis. Facts of the case, the business used property owned by one party. That property was insured by one partner. So the court said, just because the business uses the property or the property is owned by someone, it does not make it partnership property, and it does not prove there is a partnership. So joint ownership alone is not enough. Sharing profit from property is not partnership. Must look at business activity and also the intention. So let's look at Section 4B, sharing of gross return. Sharing gross return does not mean a partnership. What is gross return? Gross return means total income before deducting expenses. So just because people share money from sales, it does not automatically mean they are partners. Partnership is about sharing net profit, not just gross income. So simple explanation for you. Gross return means total sales before deducting all costs, whereas net profit is profit after deducting all costs. Only sharing net profit shows partnership intention. So a case here, Cox versus Colson, the case shows that sharing gross returns alone is not enough to prove a partnership. So sharing gross return alone is not enough, must show intention to share the net profit, and must have real business and also agreement. Now let's look at sharing of profit under section 4C. So sharing net profit is strong evidence of partnership. When people share net profit, it shows they are likely partners. But very important, sharing profit does not automatically make someone a partner. It is only prima facie evidence, which means first impression, not final proof. However, there is an exception. A person may receive money based on profit, but still not a partner. For example, receiving money to repay a debt, or payment depends on business profit. This person is not necessarily a partner. Let's look at a case Cox versus Hickman. Here, the court said that sharing profit is strong evidence, but it is not final proof of partnership. There is no automatic assumption or there is no absolute presumption. So, sharing net profit is a strong evidence of partnership. However, it is not always 100% proof. You have to look at the intention, the role, and also the relationship. Next, let's look at another important situation under section 4C. A person paid from net profit does not automatically become a partner. So who are these people? Number one is the servant, which is the employee. The second one is the agent or the representative or the contractor. So these people may receive payment based on profit, but they are still not partners. So the key idea here, being paid from profit doesn't mean being a partner. What matters is the role, the control, and the intention. So a simple explanation for you, if a person works for the business, follows the instruction, does not make business decision, that person is an employee or agent, not a partner. So payment from profit is not enough. They must have real relationship intentions and control. Employees and agents remain separate from partners. Next, let's look at section 4C, number 3. Widow or child of deceased partner. So a person who receives profit after a partner dies does not become a partner. Who are these people? Widow of a deceased partner or a child of a deceased partner. They may receive a portion of profit or annuity, but they are not partners. So the key idea here is that receiving profit does not always mean partnership. In this case, it is only financial support, not business involvement. So a simple explanation, partners may agree that if one of them dies, the wife or children will receive part of the profit. This is just an arrangement in the agreement. The widow or child does not manage the business or does not take part in the decision making. So they are not partners. So receiving profit alone is not enough. No involvement in business means not a partner. This rule protects family members of deceased partners. Next, let's look at section 4C, number 4. A person who gives loan and receives interest based on profit does not automatically become a partner. A very important condition here, that the agreement must be in writing and signed by all parties. If the agreement is only oral, this rule does not apply. So, key idea here is that lending money doesn't mean you are going to become a partner. Even if the lender earns money based on business profit, they are still only a lender or a creditor. Simple explanation, a lender gives money to a business. Instead of fixed interest, the lender receives interest depending on profit. This is still a loan arrangement, not a partnership. So important point for you to remember is that if there is no written agreement, then the protection may not apply. It can be argued that there is a partnership. So loan and profit-based interest doesn't mean that you are a partner. They must have written agreement and the lender remains separate from business ownership. Next, Section 4C, number 5, sale of goodwill. A person who sells the goodwill of a business and receives profit as payment does not become a partner. The question here is that what is a goodwill? A goodwill means the reputation of the business, the customer loyalty, and the brand name. So receiving profit as payment is not partnership. This is actually a sale agreement, not a partnership. So a simple explanation for you, a person sells a business or its goodwill, and instead of fixed payment, they receive a share of future profits. This is just a method of payment, not proof of partnership. So profit sharing can be used as payment method, but it does not always mean partnership. They must look at real relationship and also the intention. Next, let's look at the relationship of partner with outsiders, which is the third party. So every partner is an agent of the partnership. So what does this mean? When one partner acts, it is as if the whole partnership is acting. So the main principle here is that any act or omission by one partner will bind all other partners, but only if it is done within the ordinary course of business. Some important condition, if the partner acts outside the business scope, the other partners may not be bound. So each partner is an agent of the firm. One partner's action can bind everyone, and it must be within the normal business activities. So let's look at case Chan King-yue versus Lee and Wong, 1962. Here, the facts of the case, the plaintiff's husband, which is a partner, borrowed $35,000 from his wife. That money was put into the partnership account, and the money was used to pay business debts. Later, the wife asked for her money back. The other partner said he was not authorized to borrow money. So, what is the issue here? Is the partnership responsible for the loan taken by one partner? So, the court said borrowing money is a normal activity in business. So, it is part of the ordinary course of business. Therefore, the debt is binding on all partners. So, since a partner is an agent of the business, if they act within normal business activities, all partners are responsible. So, again, partners act as an agent of the firm. Acts within normal business means it will bind on all partners. Important to understand the authority and scope of business. Next, let's look at the liability of the firm. Looking at Section 7. So here, every partner is an agent of the firm and also an agent of the other partners. What does this mean? When one partner acts for the business, it is as if the whole firm is acting. So, partners represent the business. Their actions can create rights and obligations. All partners will be legally responsible together. So some important condition for you to remember is that the act must be done for the purpose of the business. If it is related to business, then it will bind all partners. But if it is not related, it may not bind the others. So again, every partner is an agent of the firm. One partner's action will contribute to firm's action and must be for business purpose. So every partner can bind the firm if the act is done in the usual way of the business. What does usual way of business means? This means actions that are normal, common, and expected in that type of business. So the main principle here for you to remember is that if a partner acts within the usual business activities, all partners are legally bound. However, there are exceptions, which is very important. The other partners are not liable if, number one, the partner has no authority, and number two, the third party knows that he has no authority or does not even believe he is a partner. So, partners can bind firm in usual business activities, must consider authority and knowledge of third party, and not all action will bind the partnership. Next, let's look at the classifications of authority. So, there are three main types. Number one, actual authority. This is authority that is clearly given to a partner. It can be written in agreement or it can be spoken, which is verbal instruction, where the partner is directly allowed to act. Number two is implied or usual authority. This is authority based on the normal business practice. Even if not written, it is understood, comes from usual way the business operates. Number three is apparent or ostensible authority. This is authority based on what third parties believe. If a party appears to have authority, the firm can still be bound. So, actual authority means it is clearly given. Implied authority means it is based on normal business. Apparent authority means it is based on third-party beliefs. All three make the firm legally bound. Now let's look at Section 8 and Section 9, which explain when the firm is bound and when it is not bound. In Section 8, acts binding the firm. So the firm will be bound if a partner or non-partner performs an act. The act is related to the business and the act is done in the name of the firm. The person is authorized. So not only partners can bind the firm, even a non-partner can bind the firm as long as they have the authority. Now let's look at Section 9 when the firm is not liable. So the firm is not responsible if a partner uses the firm's credit for personal purpose, which is not related to the business and no authorization. So if the act is not related to the business, the firm should not suffer any liability. So final conclusion for you in this particular slide is that Section 8, firm is bound when authorized business act, whereas in Section 9, firm is not bound when personal unauthorized act. Always check on the purpose of the act, authority given, and connection to the business. Now we are going to look at the liability and responsibility of a partner. So the first one here is the liability of the firm, which we are going to look at Section 11. So in Section 11, all partners are jointly liable. It means every partner is responsible together for all debts and obligations of the firm. What does jointly liable means? If the firm owes money, the third party can sue all partners together or sue only one partner individually. Important point for you to remember here is that liability includes business debts, contracts, taxes, and also court judgments, as long as it happens while they are partners. And the right of third party here is that they can sue the firm's name or sue individual partners. So when the firm sues others, the firm can also take action to sue the firm's name or all partners who join together as plaintiff. So all partners share full responsibility together. Third party has flexibility to claim, and being a partner means serious legal responsibilities. Next, we are going to look at joint liability. So what is joint liability? All partners are treated as one group when it comes to legal action. There is only one cause of action, which is to recover the debt. The key idea is that once a case is brought and decided, you cannot bring the same case again against other partners. No second chance for another separate claim. Simple explanation for you. A creditor sues the partnership. The case is decided, which they already being paid or settled. So this is the end of the case. So the creditor cannot go again and sue another partner separately for the same debt. So partners are treated as one unit, not separated. Only one legal claim is allowed. Once it is settled, there is no repeated action. Next, we are going to look at the tortious liability, which is in section 12. Here, we are going to look at the section 12, which the firm will be liable for wrongful act committed by a partner if the act is done in the ordinary course of business or with the authority of other partners. So what is tort? A tort means a wrongful act such as negligence, mistake, carelessness. So if one partner commits a wrong during business activities, all partners are responsible. So partners work as a team. If one makes a mistake in business, the whole firm is affected. So when there is a tort done in business, the firm is liable. When the partners mistake, then everyone will share the responsibility. Next is the misapplication. Misapplication of money or property under section 13. So the firm is liable if the partner misuses money or property belonging to the third party. Two situations where firm is liable. Number one, money or property received by a partner. If a partner receives money within their authority and uses it wrongly, then the firm is liable. Number two, money or property received by the firm. If the firm receives the money in the course of business and one partner misuses it, the firm is liable. So, when the firm is not liable, the firm is not responsible if the partner receives the property in a personal capacity, not as a partner. So, simple explanation, if money is received as part of business, then the firm is responsible. However, if money is received personally, the firm is not responsible. Next, Look at section 15, the misappropriation, which is the trust property. So, if a partner is acting as a trustee and misuses trust property, so the other partners are not automatically liable. So, the situation is different from section 13. Here, the partner is acting as a trustee, not purely as a partner of the firm. So, liability is limited. However, there is an exception which is very important. Other partners will be liable if they know about the breach of trust and still allow it to happen. So the recovery of trust property. If the trust money is still in the firm's possession and under the firm's control, the victim can recover the money from the firm. Next, we are going to look at the holding out under section 16. A person who represents himself as a partner can be held liable as if he is a real partner. What is holding out? It means a person acts like a partner or allow others to believe that he is a partner, even if he is not actually a partner. So if a third party relies on that representation, the person becomes liable. Let's look at case William Jacks and Company versus Chan and Yong Trading. So the fact of the case, the defendant said, I never told anyone I was a partner. However, in the court, it says he represented himself as a partner by asking for credit facilities from supplier, registering the partnership officially, and opening a bank account using partnership name. So each action shows he behaved like a partner. So therefore, he is liable as a partner. So simple explanation, action speaks louder than words. Even if you say, I am not a partner, but your actions shows otherwise, you will still be responsible. Next, let's look at crime liability. Here, we are going to look at crime when one partner commits a crime. So, if one partner commits a crime, only that partner is personally responsible. Other partners are not automatically liable. So, criminal liability is personal. It depends on individual actions, not the partnership. Let's look at case Chung Shin Kian versus PP. So the court decision, the court confirmed that partners are not jointly liable in criminal matters. Only the person who committed the offense will be punished. Next, let's look at the relationship between partners. Here, the relationship between partners is mainly based on the partnership agreement. What does this mean? It means partners decide their rights, their duties, how the business is managed, how profit and capital are shared. All these are written in the partnership deed or agreement. If there is no agreement, the Partnership Act 1961 will automatically apply. It provides default rules for partners. So, important note for you to remember under Malaysia context, in Malaysia, many partnerships are not written. They are only going for oral agreement, but still legally valid. So, if there is no agreement about profit, then the law applies. Profit will be shared equally. However, if there is an agreement, written agreement, and they agree that the profit sharing is based on their shares, then this will follow their agreement. Now look at section 26, rights and duties of partners. Now here under section 26, which applies when there is no partnership agreement. If partners do not agree on their rights and duties, Section 26 will apply automatically. Main rules under Section 26 is that number 1, equal sharing. All partners share capital equally, share profit equally, and contribute losses equally. B, indemnity or reimbursement. The firm must pay back a partner if the partner made payment for the business. The partner incurred liability for the firm. C, ordinary business conduct. Partners must act for the normal running of the business. D, preservation of business. Partners can act when necessary to protect the business or to protect firm property. So, when there is no agreement between partners, we are going to use Section 26, equal rights and responsibility, and it protects partners and ensures fairness. Next, let's look at the terminations and annulment of partnership. There are 6 main ways. Number 1, by agreement, where partners agree together to end the business. Number 2, by operations of law. This happens automatically when there is an expiration, and also notice. And number 3, death or bankruptcy. If a partner dies or becomes bankrupt, the partnership is automatically ended. And number 4, by charging on shares. If a partner's share is taken to pay the debt, partners may be terminated. Number 5, by supervening illegality. If the business becomes illegal, the partnership must end immediately. And number 6, by court order. The court can order termination if there is a misconduct, there are disputes, and the business cannot continue properly. So let's look at one by one. Termination by agreement. Here, a partnership can end when partners agree together. There are 2 main ways. Number 1 is fixed duration, which is the expiry. The partners may agree from the beginning that the partnership will last for a specific period. So when the time ends, then the partnership will automatically end. And number 2 or B is the mutual agreement. Partners can decide to end the partnership at any time as long as everyone agrees. Next, let's look at by operations of law or expiration. Here, we are going to look at Section 34. A partnership can end automatically by law without agreement in 2 situations. A, fixed term partnership, which is under Section 34(1)(a). If the partnership is formed for a specific time period, and when the time ends, the partnership automatically ends. And under Section 34(1)(b), if the partnership is created for one specific project, and when the project is completed, the partnership automatically ends. Next is looking by notice. If a partnership has no fixed duration and there is no specific time, any partner can end it by giving notice to the other partners. What does this mean? It means no need for agreement for all partners. Just one partner can decide to leave, and he must inform by giving notice to others. So an important case for you to refer here is Arif versus CEO. The court decided that the partnership ends on the date the notice is received, not when it is written, but when it is delivered. So partnership without fixed terms is flexible. Anyone can exit, but must properly notify others by giving notice. Let's look at case Tham Kok Cheong versus Loh Pui Heng. Here, they have decided to sell their business to a company, and there were 4 partners, but the 4th partner was not informed. The 4th partner only found out about the sale on 6th of April 1966. So he argued, I was not given proper notice for dissolution. So what is the issue here? Is the issue the issue of the case is that when does the partnership actually dissolve if notice is not properly given? Then the court said that the actions of the three partners selling the business shows their intentions to end the partnership. However, since the fourth partner only knew about it on the 6th of April, the partnership is considered dissolved on that date, which is on the 6th of April, not earlier. Next is by death or bankruptcy under Section 35. A partnership is automatically dissolved when a partner dies or a partner becomes bankrupt. So this applies to all partners in the firm unless there is a different agreement. What does this mean? Partnership depends on trust and personal relationship. When one partner dies or cannot manage the business or bankrupt, the partnership cannot continue as before. Let's look at case Lee Chuyam Holdings Sdn Bhd versus Khoo Yok Hwa. The fact of the case, the parties asked the court to confirm whether the partnership ends when the partner dies. So the court agreed that partnership is dissolved upon death of a partner. So here, sorry, we are going to go deeper into Section 35, especially what happens when a partner dies. So the partnership is automatically dissolved unless there was an agreement made before the death. Number one, agreement must be made before death. If partners want the business to continue, the agreement must be made while all partners are still alive. Any agreement made after death, it will not bind the deceased partner. Number two, after death, new agreement is not valid for all partnership. If surviving partners decide to continue, they are forming a new partnership, not continuing the old one. Number three, burden of proof, very important. The party claiming the partnership continues, they have to prove that there was a valid agreement and the agreement included all partners, including the deceased. Next, termination by charging on shares. Under Section 35, subsection 2. A partnership may be dissolved if a partner's shares is used to pay his personal debt. What does this mean? If a partner owes money personally, a creditor may place a charge or claim on that partner's share in the partnership. This affects the partnership business. So the partnership does not automatically end. It is up to the other partners to decide to continue or dissolve the partnership. So, personal debt of one partner can affect the whole business. However, the other parties may not want to continue, so they can choose to end the partnership. Personal debt can affect partnership, so other partners have the option to dissolve. It is not automatic, it is dependent on the decisions of the remaining partners. Next is supervening illegality under Section 36. A partnership is automatically dissolved if the business becomes illegal to continue. What does supervening illegality means? It means the business was legal at the beginning, but later, due to changes in law or situation, it becomes illegal. So, the termination is automatic. There is no need for agreement or notice. Once it becomes unlawful, the partnership must end immediately. Let's look at case R versus Kupfer. Here, the defendant was a partner in a firm with his brother. The business operated in London and Frankfurt. The Frankfurt branch ordered goods from a Dutch company. Payment was supposed to be made in London. Then, war broke out on 4th August 1914. The defendant still made payment to the Dutch company. He was then charged for trading with the enemy. So what is the issue here? Was the partnership still valid after war broke out? The court said that the partnership was automatically dissolved as soon as war was declared. No business transaction should be carried out after that. Therefore, the payment made was unlawful. Next is by court order under Section 37. A partnership may be dissolved by the court upon application by any partner. When can a court dissolve a partnership? There are several important reasons. Number one, mental disorder. If a partner becomes mentally unfit to manage business, court may order dissolution. Number two, permanent incapacity. If a partner is physically unable to continue, for example, serious illness, then the partnership can be ended. Misconduct. If a partner behaves in a way that harms the business, then the court may dissolve the partnership. Number four, persistent breach of agreement. If a partner repeatedly breaks the partnership agreement, dissolution may be ordered. Number five, business running at loss. If the business is continuously losing money, court may decide it is better to end the partnership. Number six, just and equitable. If it is fair and reasonable to end the partnership, for example, there's a serious conflict between the partners, court may dissolve it. So as a conclusion, court acts as a final solution when partners cannot resolve issues. Many reasons such as incapacity, misconduct, loss or unfair situation. This is to ensure justice and fairness. So remember the 6 ways of termination: agreement, law, death, charging, illegality, and also court. Thank you very much for your attention. I'm going to see you on our next topic.